Magandang gabi, mga future CPAs. Isang fresh na Sabado po, Char. Ayan, so good evening na pala, good evening dyan sa mga taga Manila. Hello sa mga ka-ECQ natin dyan. At sa mga nasa probinsya, I hope you are all doing well and safe. Okay, so for tonight, we will discuss law on obligations. Ayan. So para sa mga takot sa obligasyon, takot sa commitment, this webinar is for you. Okay, sige. Okay, let me just share my screen ha for a while. Okay. If you have any questions, you may reserve it after our webinar. So almost 2 hours siguro ang ating mako-consume. But I will try to trim it down to at least 1.5 hours para we can have 30 minutes for your questions, okay? And you know, our topic for tonight is very basic, di ba? Parang ito yung pundasyon ng lahat ng laws na aralin nyo when you go to your BS in accountancy, di ba? Ito yung, I think, first law subject that you will encounter when you enter BS in accountancy. So, it's a must that you have a good foundation. Pero kung wala, di ba? Kung medyo shaky ang inyong foundation sa oblicon, particularly sa law on obligation. So, let me help you tonight. Hopefully, di ba? Ma-cure natin yan na shaky foundation na yan. Okay, sige. Without much chika, let's start. Okay? So, for law on obligations, okay, of course, we need to go first with the definition. So, kayang-kaya nyo yun i-memorize. Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Okay. So, ano yung mga important points dyan sa definition? First, ito. Ano ibig sabihin ng juridical necessity? Okay. So, when we say juridical necessity, in case of non-compliance, the courts may be called upon by the aggrieved party to enforce the fulfillment of the obligation. Okay? Kaya juridical necessity kasi pwede kang pumunta sa korte in case merong non-fulfillment. Okay? So hindi lahat ng obligasyon, di ba, we can consider as an obligation under our civil code, di ba? Yung obligasyon niya na mahalin ka, hindi mo naman pwedeng pilitin yan sa korte, di ba? So when we speak of obligations, kailangan it's a juridical necessity, okay? Juridical necessity to what? To give, to do, or not to do. Okay, so mamaya hihimayin ulit natin yan. We will dissect to give, to do, or not to do. Okay, so before we go to the particulars of that later part of the definition, let us first go to the requisites. Okay, so meron dapat na active subject, merong passive subject. Okay, so kung mayroong mga nalilito sa inyo dun sa passive tsaka sa active, ang inaalala ko lang dyan, passive, so maipapasa. Okay, that is why debtor, kasi siya yung may obligasyon eh. And yung active subject, yun yung creditor, di ba? It's a two-way obligation. Dapat merong dalawang parties. Okay, may creditor and then may debtor. Okay, and then we have juridical or legal tie. Ano ito? So the juridical or legal tie are the sources of obligation, which we will enumerate in the next slide. Okay, and number 4, the number 4 requisite is the fact, prestation, or service. Ano ba yung object ng obligasyon? Di ba? Ano ba yung kailangan gawin? So it's either to give, to do, or not to do. Okay, so yan ang requisites ng isang obligasyon. Okay, so obligations may also be civil or natural. Okay, ano ba yung natural? Okay, so yung civil obligations, yan yun mismo, yung dinedefine dito sa Article 1156. Okay, ang natural obligation, this is not based on law, okay, but it's based on equity and natural law. Okay, so it do not grant a right of action to enforce their performance, so meaning barred ka or you are not allowed to file an action in court to enforce fulfillment. But because of the voluntariness in fulfillment, it may still be enforced. So parang kusa na lang. Okay? Hindi siya yung based sa sources ng obligation, pero voluntary fulfillment na lang siya. Okay? So now let's go to the sources of obligation. So you have law. Okay? So obligations derived from law are not presumed. Okay? So kailangan explicitly provided ng batas kung merong obligation. Okay, so examples of obligations under the law, the obligation to pay taxes, di ba? That's the very obvious example. We also have contracts, okay? So obligations arising from contracts naman, they have the force of law between the contracting parties and should be complied in good faith, okay? So if you remember under your oblicon, di ba? So sa contract, kailangan merong tatlong elements rin, yung tinatawag nating COC. Okay, hindi certificate of candidacy, hindi rin clash of clans. Okay, when we say COC, you have consent, you have object, and then you have cause. Okay. Another source of obligation, you have quasi-contracts. So quasi-contracts, these are juridical relations arising from lawful, voluntary, and unilateral acts. Okay, this is based on the principle that no one shall be unjustly enriched at the expense of another. Okay, so ano yung example ng quasi-contract? So you have solutio in debiti and negotiorum gestio. Okay, yung solutio in debiti, yung may na-receive ka by mistake. So since na-receive mo by mistake, you have the obligation to return it. Okay. Ang laging naalala ko dyan sa solutio in debiti is nung nag-outing kami sa Calagwas, nung law school friends ko. Tapos, part ng package nung travel agency is free breakfast. Okay, so every day, meron kaming free breakfast. On our second day, on the island, sa Calagwas Island, nag-deliver ng isang plato na sobrang daming hotdog. Okay, nung binigay sa amin, doon sa parang kubo-kubo namin. So, tuwang-tuwa kami, sabi, wow, ang generous naman nung generous naman ng travel agency. Tapos, di kain kami. Sarap-sarap na ng kain namin. Tapos, biglang yung kaharap naming kubo, sabi, asan na po yung hotdog na pinaprito namin? So, parang kami nahiya kami lahat kasi parang patay gutom kami, kinain namin yung buong hotdog, namali lang pala ng delivery. Okay? So, ang nangyari, syempre, binayaran namin yung value ng hotdog kasi hindi naman para sa amin. Okay? So, yun yung, siguro pwede nyo rin maisip by, pag sinabing solution debit. Diba? There's payment by mistake, so kailangan mong i-return. Okay? Another kind of quasi-contract, you have negotiorum gestio. So this is unilateral management of a property or a business while the owner is away. So the owner is bound to reimburse any expenses that was incurred by that person for the preservation and management of his or her property or business. Okay. Another source of obligation, you have delicts. Okay. So baka pag in-spell nyo yan, hindi yung delicts ha, delicts, okay, CTS, okay. When we say delicts, crime, okay, this is based, aside from 1157 of the Civil Code, this is based on Article 100 of the Revised Penal Code, which states that every person criminally liable is also civilly liable, okay. So kapag ikaw ay convicted for a crime, automatic na meron ka ring civil liability. Okay, and lastly, we have quasi-delicts. So quasi-delicts, these are acts or omission that causes damage to another, there being fault or negligence. So since there is damage to another, you are obliged to pay the damage. Okay, so those are the sources of obligation. Now let's go to the fact or prestation or service. Diba? Sabi natin, it's either to give, to do, or not to do. So unahin natin yung obligation to give. So what are the important points when we say obligation to give? Okay, so there is a thing, there is an object that you are bound to deliver, that you are bound to give. Okay, so kapag ikaw daw, as a debtor or the obligor, is obliged to give something to another, bago mo i-deliver, you are required by law to observe the diligence of a good father of a family. Diba? Madaming beses nyo rin yan may encounter. Okay, ano bang sinasabi nating diligence of a good father of a family? So when you say diligence of a good father of a family, hindi naman ibig sabihin that you are omniscient of the future, na talagang kailangan ma-foresee mo lahat ng harm sa iyong property or doon sa i-deliver mo. It's enough that you take precautions against any harm when there is something before you that will suggest any danger. Okay? So sa mga normal na tao, di ba, na may reasonable diligence, yung precautions na gagawin when there are circumstances that may harm or damage the property. Okay, so yun lang ibig sabihin ng diligence of a good father of a family. Reasonable diligence lang. Okay, hindi naman kailangan extraordinary. Okay, so that's the degree of care required when you are obliged to give something. How about the fruits? Okay, so as to the fruits of the thing, The creditor, he has the right to the fruits of the thing from the time the obligation to deliver it arises. Okay, ito yung general rule. Pero sa ibang mga kontrata, sa ibang specific contracts, sa sales, for example, pwede magkaroon ng ibang rule. Pero this is the general rule. The right to the fruits arises from the time the obligation to deliver it arises. Okay, kaya lang yung real right over that fruits, it will arise upon delivery because delivery transfers ownership. Okay? More on obligation to give. So, ang pwede mong ibigay na object, pwedeng determinate, pwedeng generic. When you say determinate, it's particularly designated or physically segregated from all others of the same class. Okay? So, kaya mong ma-determine, kaya mong ma-pinpoint, diba? So, it's unique. It's identifiable. Okay? When we say generic, it's not particularly segregated. Hindi siya specifically described, but it's part of a class or a mass. So that's a generic thing. Okay. So what are the distinctions when you are bound to deliver determinate thing as compared with the delivery of a generic thing? Okay. So if you are bound to deliver a determinate thing, kailangan mo rin isama dun sa bagay na di-deliver mo yung kanyang accessions tsaka accessories. Okay, so i-remind ko ulit kayo, ano ba tong accessions, ano ba tong accessories. Okay, so sa accessions, pwedeng gamitin yung mnemonics PIA. Okay, PIA. So everything that is produced, incorporated, or attached. Diba? PIA. Okay, so yun ang accessions. Ang accessories naman, these are those that are joined, included with the principal thing for its enjoyment, or perfection, okay, or for its use. Okay, so yun ang difference ng accessions tsaka accessories. Okay, so that's for determinate thing. Kapag generic thing, since hindi nga siya particularly described tsaka particularly segregated, ang obligation lang is to deliver the thing itself. Okay? As to remedy, kapag hindi dineliver, pareho sila. Ang remedy is rescission. Rescission meaning cancellation. Okay? They can also recover damages in case of breach of obligation. How about if the thing that is supposed to be delivered was lost or destroyed? Ano ang remedy ng debtor? I mean ng creditor. Okay? So, when the thing is lost before the debtor is in delay, then the obligation is extinguished. Okay? How about for generic thing? Kahit mawala yan, di ba? It does not extinguish the obligation because of the principle that genus never perishes. Okay? Dahil daw hindi mo naman particularly sinegregate, diba? So pwede mong palitan kasi hindi mo naman in-identify specifically. Okay? Now let's go to obligation to do. Anong important points dito? Okay. So when you say obligation to do, may kailangan kang i-perform na service. Okay. So what will happen if you failed to do it? Okay, what the service that was required from you. Okay, so the creditor can require you to execute the service at your cost plus damages. Okay. So you will ask, bakit wala sa remedy ni creditor na pilitin siya, di ba, to enforce the fulfillment of the obligation, meaning sabihin niya dun sa debtor or sa obligor o i-perform mo. Like for example, hinire kita na magpinta ng kwarto ko tapos hindi mo ginawa. Bakit hindi kita pwedeng pilitin? That's because our constitution prohibits involuntary servitude. Okay, so kung ayaw niyang gawin, di wag. Parang gano'n. So hindi pwedeng pilitin, di ba? Walang pilitan. That is why ang remedy na lang ni creditor is ipa-execute sa kanya at his cost, di ba? Pwedeng ibang tao tapos babayaran niya yung cost plus damages. Okay. What if it's in contravention of the tenor of the obligation? Halimbawa, sabi mo dun sa pintor, pinturahan mo yung kwarto ko ng black kasi medyo heartbroken ako, medyo gusto ko yung madilim lang lagi yung paligid ko. Tapos ang ginawa ng pintor, pininturahan niya ng pink. Okay. So anong magiging remedy mo doon? Okay? So, pwede mong ipaayos, di ba? You can have it undone and then you can have it executed again at his cost and then demand damages. Okay, so that's for obligation to do. How about obligation not to do? Okay. So, not to do, pinoprohibit ka na gawin ng isang bagay, pero ginawa mo pa rin. So, what is the remedy of the creditor. Okay, so the debtor may be required to undo what has been done that is prohibited at his expense. And in addition, pwede rin magkaroon ng damages. Okay, so speaking of damages, we have Article 1170. Ito, ano to, parang isa siyang article na laging binabasihan or laging ginagamit na legal basis in case there is a claim for damages. Okay, so ano yung Article 1170? So those who are in the performance of obligation daw, so take note, in the performance ha. Okay, so sa performance ang ating focus, hindi doon sa perfection ng obligations, sa performance pa lang. So in the performance of their obligations are guilty of fraud, negligence, or delay, or those who in any manner contravene. Okay, so pwedeng ang mnemonics nyo dyan ay FNDC. Okay, so fraud, negligence, delay, contravention of tenor, damages. Okay, so ito yung apat na pwedeng mag-give rise to damages. Okay, so let's discuss each. First, fraud. Okay, so what are the kinds of fraud? So we have fraud in obtaining consent. So it can either be dolo causante or dolo incidente. Okay, so baka meron na naman sa inyo mag-isip, ano nga yung dolo causante? Ano nga yung dolo incidente? So pag nakaka-encounter kayo ng mga Latin terms, pag nag-aaral kayo ng batas, minsan makukuha nyo sa sa kahit hindi nyo naintindihan, makikita nyo sa key terms nung Latin term na yon, diba? So like here, dolo causante, so you can derive the word cause. Okay, so when we say dolo causante, this is fraud of serious character that was employed to secure the consent or to encourage the other to perfect the obligation. Okay, so it's of serious character, so it vitiates consent. Okay, so that's dolo causante. Okay, ang incidental fraud naman, just the same, it was employed in obtaining consent. However, it's not serious in character. Okay, so hindi naman siya deal breaker. Okay, pwedeng may fraud pero kahit sabihin na natin na dinisclose or walang fraud, the other party would have still entered the contract or the obligation. Okay, so that's dolo causante or dolo incidente. Okay, so when the fraud was employed in obtaining consent, di ba? As you learned, or as you will learn, kung wala pa kayong contracts, the contract is voidable. Okay? So, second kind, in the fulfillment of the obligation. Okay? So, dito yung pinag-uusapan natin. Okay? So, kaya magkakaroon ng damages. Okay? So, any responsibility arising from fraud that is demandable in all obligations. Okay? And any waiver of an action for future fraud is void. Okay? So kahit lagyan mo pa dyan sa kontrata nyo or sa agreement nyo na may waiver for future fraud, that is void. Okay? That is an absolute rule. Okay, now let's go to negligence. Okay. So ang fraud pala is dolo. Negligence naman is culpa. Okay? So negligence, this is the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Okay? So kung walang designation or walang statement as to the diligence required from the parties, ang general rule natin, diligence of a good father of a family or ordinary diligence or reasonable diligence. Okay? Kailan mo ba masasabi na negligent ang isang tao? So by jurisprudence or by Supreme Court decision, meron na tinatawag na test of negligence. Okay, so you ask the question, did the defendant in doing the alleged negligent act use that person would have used in the same situation? If not, then he is guilty of negligence. Okay, meaning, kung ang ordinaryong tao ba nilagay mo sa ganong circumstance, ano kaya yung gagawin niya to protect his property and to protect the others or to protect the life and limb of the others, di ba? Kung ginamit niya yung necessary na diligence, then hindi siya negligent. Pero kung hindi, then that's the time that he is guilty of negligence. Okay, so as two kinds, we have culpa contractual. So ito yung mini-mention ng 1170. So this is negligence in the performance of a contract. We have culpa acheliana. Okay, this is actually the Latin term for quasi-delict. Okay, so these are acts or omissions that cause damage to another, there being no contractual relation between the parties. And we have culpa criminal. So ito yung Latin term din doon sa mga napapanood nyo sa news na reckless imprudence resulting in damage to property. Okay, so yan yun. So this is negligence that results in the commission of a crime. Okay, now let's go to delay. So delay naman is mora. Okay, hindi moira ha, mora. Okay, so delay, this is non-fulfillment of an obligation on time. Okay, so kapag in delay ka daw, may damages. Okay. And as you will learn later on, sige, mention na natin, kahit fortuitous event pa ang cause ng loss, as long as you are in delay, you will still be liable. Okay, so as to kinds, you have mora solvendi on the part of the debtor, you have mora accipendi on the part of the creditor, and compensatio morae both parties. Okay. So kung nalilito ka ulit sa Latin terms, pwede mo ulit gamitin ito. Okay. So, accipendi, may i-accept. So, ibig sabihin, creditor. Diba? So, pwede nyo yung gamitin para, mga memory aid, para mabilis nyong maalala. Kasi sa dami ng Latin terms, di ba, na may encounter nyo when you are studying law, then at least you can, that can aid you in memorizing or at least remembering. Okay? So, kailan ba mako-consider na in delay ang isang debtor? Okay? So, our rule, kapag walang demand, walang delay. Okay, no demand, no delay. Okay, so the demand can either be judicial or extrajudicial. Okay, so that's our general rule. Ano ang exceptions? Okay, first, if the law so provides, okay, na hindi kailangan ng demand, tapos may delay na. Okay, second is when there is express stipulation. Like for example, sabi ng parties, okay, you are bound to deliver this thing on August 11 without need of demand, mga ganon. And if you fail to deliver, you are already in delay. Okay, so may express stipulation na. Okay, when time is of the essence, ayan. So good example dito, isang case na may namatayan na family. Okay, so yung tatay bumili siya sa hardware store ng panggawa ng coffin, and then yung parang gagawin na kubo-kubo kung saan ibuburol yung asawa niya. So bumili siya ng mga materials sa hardware, kaya nga lang hindi pa daw na-deliver. Okay. So bago mamatay yung nanay, sabi, ilibing niyo ako before December 25 para hindi daw masira yung spirit. Okay. So sinabi rin yon nung bumili na tatay doon sa hardware store, kaya nga lang yung hardware store medyo naging negligent doon sa delivery. Hindi nila naayos yung delivery as they promised. Kasi sabi nila, made-deliver yan agad. Ganyan. So, ayun, to cut the story short, hindi na-deliver before, I think na-deliver December 24 na. So, impossible na malibing before December 25. So, ayan. So, kahit hindi nag-demand doon yung tatay and the family, time is of the essence, di ba? In-inform si hardware store na, kailangan namin to kasi nga may wish yung namatay na dapat malibing siya before December 25. So, hindi nila pwedeng i-insist na hindi ka naman nag-demand eh. Hindi mo kami ni-remind agad-agad na ma-deliver na yung hardware supplies. Okay? So, if time is of the essence, there's no need for demand in order for the debtor to be in delay. Okay? Or if demand would be useless. Okay? All right. That's the exceptions for our general rule that no demand, no delay. Okay? And ito pala lastly, sorry. In reciprocal obligation, okay, so for example, both parties have their own obligations. So the other party will be in delay from the moment one of the parties fulfills his obligation. Okay? So kung for example, sa sale, for example, yung seller nag-deliver na nung binebenta niya, tapos hindi pa nagbabayad yung buyer. Okay? So from the moment that one of the parties fulfills his obligation and the other party wasn't able to perform his obligation, then delay begins as to the other party who was not able to fulfill his obligation. Okay? So that's for delay. Okay? So relative to our discussion of delay, di ba na-mention ko na kanina, so let's now discuss fortuitous events. Okay. Ano ba ang fortuitous events? So these are events that are not foreseen or which though foreseen are inevitable. Okay, so these are commonly known as acts of God. Okay. So, general rule, no one shall be liable for fortuitous event. Okay, so kung may loss or destruction or impairment or there was a failure to perform an obligation, if the cause was fortuitous event, no liability. So that's our general rule. What are the exceptions? Okay. Before we go to the exceptions, let us first discuss the elements para mag-apply itong general rule. So una, dapat independent of the debtor's will. Okay? Kaya nga, di ba, sabi ko, commonly known as acts of God. Di ba? Hindi by human doing, hindi by human intervention. Di ba? So it's beyond their will. Okay? Pangalawang requirement, it cannot be foreseen or it cannot be avoided even though it's foreseen. Pangatlo, it would render the debtor, it would render impossible the debtor to perform his obligation in a normal manner. Okay, and then lastly, and very important, dapat walang participation si debtor in the aggravation of the damage. Okay, so dapat lahat ng elements na to present bago masabi nating exempted ka from liability because of fortuitous event. Okay. For every general rule, there is always an exception. Okay, so what are the exceptions? First, when the law provides, okay, so if the law expressly states na kahit may fortuitous event, liable ka, then wala ka magagawa doon. Second, express stipulation, the parties can waive na even though there was loss or non-fulfillment because of fortuitous event, they are still liable, then they can still be held liable. Okay, and then number 3, nature of the obligation requires the assumption of risk. Okay, so it depends on the object. So kung yung object ng obligation, it's something that you should take extra precautions and then you fail to do so, then you may still be held liable despite the fact that the thing was lost because of fortuitous event. Okay. And other exceptions, so if the loss was partly due to the fault of the debtor, di ba? Sabi kasi natin dapat walang part sa aggravation si debtor as to the damage done to the thing. Okay? So kung meron siyang fault, then hindi niya pwedeng sabihin o hindi siya pwedeng magpa-exonerate sa liability because of fortuitous event. Okay. Number 2, when the debtor promised the same thing to two or more people who does not have the same interest. Okay? If the thing delivered is generic, di ba? Kasi genus never perishes. When the debtor is in delay, okay, ayan ha. So kapag in delay ka, you performed your obligation beyond the time agreed upon, then kahit mawala yung bagay because of fortuitous event, then you are still liable. Okay? Or when the liability proceeds from a criminal loss. Okay? So that's fortuitous event. Okay, now let's discuss the power to rescind in obligations. Okay, so when we say rescind, like what I said, it refers to cancellation. Okay, so in reciprocal obligations, the power to rescind is implied. Okay, so kung merong breach ng obligation in case of reciprocal obligations, impliedly considered na siya. Okay, kahit walang agreement na kapag hindi ka nag-comply sa obligation mo, pwedeng i-cancel. So, batas na mismo nagsasabi na pag may non-fulfillment of an obligation in case of reciprocal ones, then either of the parties can rescind in case of breach. Okay. Actually, the proper term here is resolution. Ito yung recognized na term for this article 1191. Yan yung proper term, resolution. Okay, kasi when we say rescission, dun talaga siya mag-a-apply dun sa rescissible contract. So para hindi magkalituhan, ang proper term dito sa 1191, this is resolution. Okay, kahit ang ginamit na term is rescind. Okay? So aside from that, the injured party may also choose between the fulfillment and the rescission of the obligation. Kung ayaw niya i-rescind, pwede rin namang fulfillment, but in addition to that, meron siyang right to claim damages. Okay, so that's rescission. Okay, more on nature and effects of obligation. Papasadahan natin halos lahat ng articles. Okay, 1176, ito naman ay for payment of a monetary obligation. Okay, so ang sinasabi lang nito, kung for example meron kang utang, meron kang monetary obligation, kapag merong interest sa isang obligation, tapos nag-issue si creditor ng resibo for principal without stating anything about the interest, merong presumption na bayad na yung interest. Okay? And kapag merong resibo for later installments, in case installment yung bayad ng monetary obligation, meron ring presumption that the previous installments have been paid. So this is a disputable presumption. So the other party can still present evidence to contradict this presumption. Okay, more on monetary obligations. So what are the remedies of a creditor? To enforce payment of his claims against the debtor. Okay, so paano kung hindi ka mabayaran? Di ba? Madaming ganito eh. Nagpautang kay Besh, hindi na bayaran. So what are your remedies? So first, you can exact performance, meaning you can enforce fulfillment of the payment of the obligation. In addition to that, you also have the right to exhaust the assets in possession of the debtor, except those that are exempt. Okay, so pwede mong i-claim na yung assets na lang, ibenta in order for it to serve as payment for your monetary claim. We also have action subrogatoria. Okay, so from the word subrogation, so this means that you as the creditor, you can exercise all rights and actions of the debtor except those that are personal to him. Okay. Another, you also have the right of action pauliana. So action pauliana naman, this is the impugning of the acts which the debtor may have done to defraud the creditors. Okay, so for example, si debtor, kasi ayaw niyang bayaran yung creditor niya, pinagbebenta niya lahat ng properties niya. Okay, so you as the debtor, you can file an action to impugn the validity of those deeds of sale, for example, kasi binenta lahat ng properties, di ba? You can say na this is done to defraud us. However, take note that before you can file an action pauliana, you must have exhausted all the remedies. Diba? You should have availed first of fulfillment of the obligation, in-exhaust mo na yung assets niya kasi this remedy is subsidiary. Okay, so hanggang meron ka pang remedies, hindi mo muna pwedeng avail yung action pauliana. Okay, so those are the remedies of a creditor. Okay, more on nature and effects of obligations. Okay, principle of transmissibility of rights. Okay, general rule, all rights are transmissible. Okay, so halimbawa may pautang si parent, di ba? So si parent ang creditor, kapag namatay si parent, pwedeng ipamana, di ba? Pwedeng ipamana sa mga anak. Okay, how about sa other side? May utang yung parent, pwede bang mamana nung mga anak? Okay, the answer to that, yes, but it's limited to the amount that they received as inheritance. Okay, so general rule, lahat ng rights acquired in virtue of an obligation are transmissible. That's only the general rule. Okay, what are the exceptions? If the law itself prohibits the transmission of the right. Okay, like for example, the right to public office, di ba? Kahit mamatay ka or whatever, hindi mo pwedeng ipamana yung right to public office, di ba? Hindi mo pwedeng ipamana sa anak mo para ma-save ka from criminal liability. Okay? So that is something that you cannot pass on or transmit. Okay? We are against political dynasties. Okay. Second, if there is express stipulation prohibiting transmission. So dito yung parties na mismo yung nag-agree, ayaw nila ng transmission. Third is if by nature not transmissible. Like for example, sa isang marriage, di ba? A marriage is a contract. Hindi mo naman pwedeng i-transmit, di ba? Hindi mo naman pwedeng i-transmit yung right mo as a husband or a wife. Okay? So those are the exceptions for the principle of transmissibility of rights. Now let's go to kinds of obligations. Okay, so as you can see on your screen, in-enumerate lang yung kinds of obligations. So let's discuss one by one. Okay, let's start with pure and conditional obligation. Okay, so when we say pure, walang condition, walang term. Okay, it's demandable at once. On the other hand, when we say conditional obligation, then there is a condition. So it may be on the acquisition of right or on the extinguishment of the obligation. Okay? So, leading to that, let us discuss condition. Ano ba ang condition? So the simple definition of a condition, it's a future uncertain event. Okay. So although by nature, di ba, ang pagpasa nyo sa CPA board exams, that is a future uncertain event. But you claim already that you will pass the CPA board, so don't make it as a condition, di ba? It should be a period. Kasi ang period, that is a future certain event, di ba? So passing the CPA board exam should not be a condition. Okay, make it certain. It will be certain because you will make it happen, di ba? By studying and by putting all the work that is necessary. Okay, kinds of conditions. So we have suspensive, we have resolutory, we have potestative, we have casual, we have mixed. Okay, so sa mga nalilito sa suspensive tsaka resolutory, again, let's use memory aids para mabilis yung maalala, di ba? So from the word itself, suspensive, di ba? It's suspense. Okay, so when we say suspensive condition, wala munang obligasyon. Kapag nangyari siya, saka magkakaroon ng obligation. Kaya suspensive, di ba? It suspends the obligation. Okay, so that's suspensive. On the other hand, kapag resolutory, it resolves the obligation. Okay, so kapag nangyari yung obligasyon, tapos na, extinguish na yung obligation. Okay, demandable at once yung obligation, pero pag nangyari yung resolutory condition, extinguish na yung obligation. Okay? So sana wala nang malito sa suspensive tsaka resolutory. Okay. Another kind of condition, you have potestative. When we say potestative, this is a condition that depends upon the will of only one of the contracting parties. Okay. If it's a potestative condition, it's on the part of the debtor, we distinguish, is it suspensive, is it resolutory? If the potestative condition is suspensive on the part of the debtor, the obligation is void. Okay, so suspensive meaning walang obligation, di ba? The happening will give rise to the obligation. So potestative, it depends on the will of the debtor. Bakit void? Kasi kung suspensive potestative condition siya, tapos it depends on the will of the debtor, you cannot expect that condition to happen, di ba? Kasi suspensive condition gives rise to the obligation. So kung sa part yun ni debtor, di ba, siya yung magkakaroon ng obligasyon, ipe-prevent niya na mangyari yung condition para walang condition. So the law itself provides na void yan. Okay? If it's resolutory, it's valid. Okay? So you distinguish ha, if it's suspensive potestative condition, the obligation is void if it's on the part of the debtor. How about if it's on the part of the creditor? The obligation is valid whether suspensive or resolutory. Okay? Casual condition, it depends upon chance or will of a third person. You also have mix, so partly by will, partly by chance. Okay? How about impossible conditions? So impossible conditions disannuls the obligation which depends upon them. Okay? So for example, may obligation nakalagay doon, I will give you 1 million pesos if Batman comes tonight. Parang gano'n. So it's an impossible condition, di ba? Since it's impossible, it annuls the obligation which depends upon them. Okay, so this is the rule on obligations. Okay, so hindi lang yung condition yung void, yung buong obligation na nakadepende doon sa condition. Okay, if divisible yung obligation, so yung part na hindi apektado ng impossible condition, pwede pa rin namang maging valid. Okay, if it's not to do an impossible thing, like for example, I will give you 1 million provided you do not transform into Batman again. Okay, so it's not to do an impossible thing. So it's just considered as not having been agreed upon. Okay, so valid pa rin yung obligation. Okay, positive condition. So this refers to condition that some event will happen at a determinate time. So the obligation is extinguished as soon as that time expires or if it has become impossible na hindi na mangyayari pa yung condition. Okay, negative condition, it refers to an event that will not happen at a determinate time. Okay, so here the condition shall be deemed fulfilled at such time as they have probably contemplated. Okay, so bearing in mind the nature of the obligation. Okay, More on conditional obligation. So ano ba ang rights ng parties before the fulfillment of the condition? So as to creditor, he may avail appropriate actions for the preservation of his right. Okay. As to the debtor, kapag nagbigay na siya, by mistake, akala niya liable na siya, pero hindi pa na-fulfill yung condition, pwede niyang ma-recover. Okay? Take note of this. The condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. Okay. So kung si obligor, di ba, nag-perform siya ng acts that voluntarily prevents the fulfillment of any condition, ang effect is deemed fulfilled. Therefore, it will give rise to the obligation. Okay, so you take note of this. Okay. So ano mangyayari kapag na-fulfill na yung condition? It will retroact to the day of the constitution of the obligation. Okay. Exceptions, okay, if it's a reciprocal obligation and unilateral, in case the debtor keeps the fruits and interest received before the fulfillment of the condition. Okay, more on conditional obligation, paano kapag nawala, nasira, or nag-improve yung determinate thing before the fulfillment of the condition. Like for example, sabi sa'yo ng ninong mo, I will give you 500 square meter residential lot when you pass the 2021 CPA board exam and places number 1. Ganun yung condition. Okay, so ano mangyayari kapag nawala? Like for example, yun nga, paano ba mawawala ang lupa? Like for example, nagkaroon ng typhoon, tapos biglang na-inundate ng water yung lupa, natabunan na ng tubig, like for example. Okay, so what are the effects? If it's without debtor's fault, then the obligation is extinguished. If it's through the debtor's fault, then he is still obliged to pay damages. Okay, so kahit hindi pa na-fulfill yung condition, may damages na kasi nawala yung bagay because of his fault. What will happen if there is mere deterioration? Okay, hindi naman nawala, nag-deteriorate lang. Okay. If it's without debtor's fault, the impairment shall be borne by the creditor. Okay. If it's with debtor's fault, the creditor, may choose between rescission or fulfillment plus damages. Okay, so yun ang remedies. Okay. Paano naman kung nag-improve? Like for example, tumaas yung value. If it's by nature or by time, then the improvement shall inure to the benefit of the creditor. Okay, kasi di ba magre-retroact upon the fulfillment of the condition. So kung nag-improve, ikaw yung mag-benefit from the improvement. What if at the expense of the debtor? Like for example, yung lupa na pinangako sa iyo ng tito mo, nagtayo siya doon ng bahay. Di ba? Ang ganda ng drawing ko ng bahay. Okay. So meron ka bang karapatan doon sa bahay na tinayo niya? Okay. So your right is only a mere usufructuary. Okay, so you have the right to use and the fruits of the thing. Okay? So in case of fulfillment of resolutory condition, di ba sabi natin kapag resolutory condition, it extinguishes the obligation. So kapag extinguish na yung obligation, i-return na nung parties kung ano man yung na-receive nila. Okay. In case of loss, deterioration, or improvement, yung diniscuss natin previously, that will apply. Okay, so that's Article 1189, yung loss condition, tsaka loss improvement, tsaka deterioration. Okay, so let's give an example. Okay, naka-open yung Facebook ko eh. Hindi ko alam kung makikita ko yung mga sagot. Okay, so basahin ko lang yung problem na nakikita nyo sa screen. So Scotty, ayan, executed 2 documents, one in favor of Pau and another in favor of Jinky. So yung mga updated dyan sa chismis, alam nila kung sino yung tinutukoy ko dito. Okay. So in the document executed in favor of Pau, Scotty wrote, sabi niya, ito si Pau, ito si Jinky. Di ba? Updated sa chismis. Okay. So sabi ni Scotty, to Pau, my one and true love, I promise to give you my Toyota Fortuner 2016 model when I feel like it. So yun yung document na in-execute kay Pau. Okay. Paano naman yung kay Jinky? Sabi ni Scotty doon sa document na executed in favor of Jinky. Sabi niya, to Jinky, my moon and my stars, I obligate myself to pay you the 100,000 I owe you when I feel like it. So our question, what is the status of the obligations? Okay. Tingnan natin kung may may magko-comment. May shout out kapag nag-comment na tama. Okay. Puro ang comments puro names. Sabi ni Princess Ivy, Armas void. Okay, so pareho void. Pareho void. So yun ang ating first entry, pareho daw void. So void yung kay Pao, void yung kay Jinky. Okay. Void, void. Ang makakuha ng tamang sagot, magkakajowa. Kaya madaming single na accountancy students kasi hindi pa nakukuha yung tamang sagot. Okay. Void daw. Puro void yung sagot. Okay. Right? Sige. Okay. Yung mga sumagot ng void, partly correct yung sagot nyo. Okay. Why? Alin dito yung void? Okay. Yung document na in-execute ni Pao, ni Scotty in favor of Pao. Okay? Ito ay void. Void tulad ng pagmamahal ni Scotty kay Pao. Okay? Okay. Alright. So, may nakita ko na nagbigay ng reason. That's correct because it's a suspensive potestative condition that is dependent upon the will of the debtor. So, correct, that is a void obligation. Itong pangalawa kay Jinky, void pa rin ba? Do you think this is still void? May nag-comment na ng valid, Charmaine Raras. Bakit kaya valid, Charmaine Raras? Kapag nasagot mo yan, yan na. Magkakajowa ka. Baka yung mga hindi sumasagot, meron na kasing love life. Congratulations. Okay. So bakit itong pangalawang document, hindi siya magiging void? O, sabi yung kay Jinky daw void. Puro void. Okay. Valid yung una po and void yung pangalawa, question mark. Sabi ni Catherine Bautista. Okay, puro void. This is the void. Okay. Okay, like what I said ha, itong document tama kayo dyan, void. Pero itong pangalawa, that is a valid obligation. Bakit? Kasi the document, kahit sabihin natin nakalagay dyan, when I feel like it, di ba? You failed to notice this one. I obligate myself to pay you the 100,000 I owe you. Okay, meaning there is already a pre-existing obligation based on an agreement or a contract. Okay? Itong when I feel like it, this can be interpreted to mean as, alam nyo yun, yung when my means permit me to do so. Okay? So ang remedy dito, ipapaset sa courts or the parties will agree kung kailan yung period nung fulfillment ng obligation. Okay, this is actually not a conditional obligation na suspensive potestative on the part of the debtor. Okay, so meron na existing obligation, no? Di ba? Meron ng express na statement that I owe you 100,000. Okay, itong when I feel like it, we can interpret it as if it's yung the same as when my means permit me to do so. Okay? Sabi natin, meron dyan na specific na provision sa oblikon nyo. When we say when my means permit me to do so, that is an obligation with a period. Okay? So it's not a condition. Okay? Alright. Okay. Kasi daw may obligate. Sige, push nyo yan. Okay. So in-explain ko na ha. So yung mga hindi nakakuha, chat nyo na lang yung mga nakakuha. Okay? Sige. Thank you so much. So yung mga hindi nag-chat na nakuha nila yung tamang sagot, congratulations. Abangan na lang ang jowa na ipapadala ni Sir Wency. Okay, abangan nyo. Okay, sige. Alright. So, dahil na-mention na natin yung obligations with a period, let us now go to obligations with a period. Okay. So, when we say period, like what I said, this is a future certain event. Diba? So, dapat ang pagpasa ng CPA board, that is a period. Okay, dapat it's a future certain event. Okay? So, nung nag-aaral ako ng oblicon, may ganun talaga akong note sa aking notebook. Passing the CPA board exams is a period. Oh, diba? Oh, that is claiming, diba? Claiming what you want. Diba? And sabi dun sa Alchemist, diba? When you want something, the universe conspires in helping you achieve it. Okay. Diba? So, abang-abang sa jowa. Yes. Okay. Sige. So, a period can also be resolutory, tsaka suspensive. So, it's if it's resolutory, then it take effect at once. It's demandable at once. And then, it is extinguished or terminated upon arrival of the day certain. Okay? For example, I will lend you my car until the sitting president dies. Charot lang. Ganon. So it's still a period, di ba? It's future and certain, although hindi alam kung kailan. Okay? If in case of loss, deterioration, or improvement, yung rules na diniscuss natin under Article 1189, that will still apply. Okay? If there is a period designated, there is a presumption that it's for the benefit of both the parties. Okay? Unless from the tenor, it's only for the benefit of one. Okay? So, paano kapag may na-deliver before the arrival of the period? Pwedeng i-recover with fruits and interest. Okay. Ito yung sinasabi ko. When we say, when my means permit me to do so, that is an obligation with a period. Okay? So, kapag nag-execute kayo, for example, ng promissory note, I will pay you 100,000, diba? When my means permit me to do so. Okay? Sabi ng batas, that is an obligation with a period. Okay. Okay, so the courts may fix the duration kung kailan. Okay? Even if it's dependent upon the will, pwedeng lumapit sa korte, i-fix yung period. Tapos kapag na-determine na ng court yung period, like for example, payable on this date, okay? Then binding na yon sa parties. Okay, hindi na nila pwedeng baguhin. Okay. So when will the debtor lose the right to make use of the period? Like for example, binigyan siya ng 90 days to pay the obligation. Okay, so kailan mawawala yung benefit niya doon sa 90 days? Okay, so ang mnemonics niyo dyan, I give a. Okay, i-give a. Okay, so i-give a or I give a. Okay, I stands for insolvent. Kapag nag-insolvent si debtor, mawawala na yung right to make use of the period. Meaning, demandable at once na yung obligation unless meron siyang binigay na guarantee or security. Okay, second reason, if the guarantees or securities promised were not furnished, hindi binigay. Another reason is when there is impairment of the guarantees or securities. Okay. Or even though nawala because of fortuitous event, mawawala rin yung right to make use of the period unless magbigay siya ng equivalent that is equally satisfactory. Okay, letter V, if he violates any undertaking in consideration of which the creditor agrees to the period, and A, the debtor attempts to abscond. Okay, so these are the circumstances when the debtor loses his right to make use of the period. Okay, so that's for pure and conditional. Okay, okay pa ba kayo? Okay, wait lang, inom lang ako tubig. Okay. All right. So now let's go to alternative and facultative. Okay, ano ba yung alternative obligation? So sa madaling sabi, kapag alternative obligation, madami yung prestations na pwedeng ibigay, kaya nga lang, the complete performance of one is already sufficient to extinguish the obligation. Like for example, I oblige myself to give you a bag, a watch, or a ring. Diba? So, hindi ibig sabihin na lahat ng tatlong yon demandable. Meron ka lang na karapatan mamili. Okay? So, kanino ba yung karapatan mamili? Okay. General rule, kay debtor. Okay? So, kung sino yung may obligation. Okay? Siya yung may karapatan mamili. Unless, merong express na grant kay creditor. Okay? So, kapag si debtor yung may right to choose, he shall not choose those that are impossible. Okay? Or unlawful. Okay. However, if the debtor cannot make a choice because of the creditor's acts, then the debtor can already rescind the contract with damages. Okay? So when will the obligation cease to be alternative and become a simple obligation? Okay? So it will become a simple obligation from the time that there was communication from the debtor to the creditor. Okay? So kung kailan nakapili ka na ba? Alin yung ibibigay mo sa akin? Okay? So from the time it was communicated to the creditor, then it is already converted to a simple obligation. Okay? Or second, kung isa na lang yung possible na pwedeng i-deliver, then simple obligation kasi wala nang choice. Or if the creditor was given the right to choose and kinommunicate niya na rin kay debtor. Okay, so take note that the choice shall not produce effect except from the time it was communicated. Okay, kailangan i-communicate mo sa other parties. Hindi enough na yung sabi mo, pinipili kita. Charot. Pinipili ko ito, like for example. So, kailangan i-communicate mo. Okay. Now, let's go to the rules in case mawala yung alternatives, di ba? Before the choice was communicated to the other party. So what are the rules? Okay. Let us distinguish if the right is with the debtor and if the right is with the creditor. If the right of choice is with the debtor, these are the rules. Okay. So kapag nawala lahat by fortuitous event, or nawala majority, for example, ng fortuitous event because of his fault. Diba? So for example, diba, may obligation to give a ring, a watch, or a bag. Okay. So paano pag nawala yun lahat by fortuitous event? Or nawala yung bag, for example, dahil nasunog, dahil sa kapabayaan ni debtor. Anong mangyayaring ngayon? So since ang right of choice is with the debtor may still deliver any of the remainder. Okay, or those that still subsist. Okay, kasi sa kanya naman yung right of choice. Okay. Okay. Now, what if lahat nawala because of fortuitous event? Okay, we apply our general rule, di ba? No one shall be liable for fortuitous event. That is why the debtor's obligation is already extinguished. Okay. Now, what if all of the prestations was lost because of the debtor's fault? Ano yung karapatan ni creditor? So the debtor shall now be held liable to pay the value of the last thing that was lost plus damages. Okay, last thing. Okay, so those are the rules if the thing is lost and the right of choice is with the debtor. Now, what if the right of choice is with the creditor? Okay. Now, if only one or some was lost through fortuitous event, then the debtor shall deliver which the creditor should choose among the remainder. Okay? So, since nawala by fortuitous event yung iba, pili ka na lang creditor doon sa mga natira. Paano naman kung nawala lahat fortuitous event? Again, we go back to our general rule under Article 1174. No one shall be held liable for fortuitous event. That is why the obligation is extinguished. Okay. Now, what if some or one was lost through the debtor's fault? What is the right of the creditor? The creditor may choose any of the remaining or the price of that thing that was lost because of the debtor's fault plus damages. Okay, so kahit nawala na yon, pwedeng piliin ni creditor kasi sa kanya yung right of choice. And then may karapatan pa siya for damages. What if all are lost through the debtor's fault? Then the creditor may claim the price of any of them plus damages. Okay, so compare nyo yan dito. Di ba? If the right of choice is with the debtor, ang liability ni debtor, value of the last thing that was lost plus damages. Dito, si creditor pwedeng mamili any of them plus damages. Okay? So that's for alternative obligations. Now let's go to facultative obligations. So ano naman ang facultative obligations? So these are obligations na merong substitute. Okay? So may principal thing tapos merong pwedeng i-substitute doon sa principal thing. Okay, so what are our rules in case the principal thing was lost or in case the substitute was lost? Okay, so let's distinguish before substitution ba or after substitution. If it's before substitution, okay, if the principal thing was lost through fortuitous event, okay, again, dapat memorize nyo na to. Pag fortuitous event, extinguish yung obligation kasi walang magiging liable for fortuitous event, generally. Okay, now what if the principal thing was lost due to the debtor's fault? Then the debtor shall be liable for damages. Okay. What if yung substitute yung nawala? Diba? For example, sabi ni debtor, I oblige myself to give to you a watch, or in exchange or as a substitute of the watch, I oblige myself to give you a ring, for example. So paano kung nawala yung ring? Okay. So since before substitution naman, wala naman kaming pakialam, di ba? Kasi hindi pa naman nag-substitute. So kahit nawala yung ring, kahit kasalanan pa nung debtor, hindi siya liable kasi wala pa namang substitution, di ba? Okay, so that's our rule before substitution. Now, how about after substitution? Okay, so after substitution, meaning yung substitute, yun na ngayon yung liability ni debtor. Okay, so paano kung nawala yung principal thing? Okay, so kung yung principal thing ang nawala, wala na tayong pake kung ano yung cost ng loss kasi nga nag-substitute na. Okay, so even though the principal thing was lost through the debtor's fault, then the debtor is not liable. Okay. May concern tayo sa substitute. What if the substitute was lost through fortuitous event? Again, obligation is extinguished. Okay. If it's through the debtor's fault, damages. Okay. So that's for alternative and facultative obligations. Okay. Now let's go to the more important classifications of obligations. Ang favorite, di ba? Sa board exams. So we have joint and solidary obligations. Okay. So when you say joint, di ba, the credit or debt is divided as many equal shares as there are creditors or debtors. Okay, so ang liability dito ng debtor is only proportionate, tapos ang right ng creditor is only proportionate as well. Okay. And kapag solidary, ito yung principle natin na one for all for one. Okay, so dito kapag sa solidary debtors, then all of them are obliged to pay the entire obligation. Kapag solidary creditors naman, they can claim the credit as a whole. Okay, but take note, the concept of joint and solidary obligation only applies if there are multiple parties. Okay, hindi naman pwedeng 1:1 tapos biglang joint tsaka solidary. Okay. So, kailan mo malalaman kung solidary obligation? You determine from the tenor of the instrument or the terms used in the instrument. So, pwedeng nakalagay dyan jointly and severally, pwede ring individually and collectively, minsan nilalagay in solidum. Yan. So, take note of the terms. Okay. Kapag joint naman, ang usually ginagamit, proportionately, pro rata, mancomunada, yan, or mancomunada simple, yan. Okay, so pwedeng dyan kayo lituhin sa mga terms na yan. Okay? So dapat, like what I said, there is concurrence of two or more. Okay, multiple parties. Okay. Ang general rule natin, kapag may multiple parties, like for example, 2 or more debtors or 2 or more creditors, general rule natin, joint. Okay, we do not presume solidarity. Okay, so dapat, ang presumption natin is joint. Unless, okay, so these are the exceptions, when the obligation expressly so states. Okay, so dapat nakalagay doon na solidary yung liability. Kung walang nakalagay, kung silent yung problem, ang general rule is joint. Okay? Another exception, when the law itself requires solidarity. And number 3, when the nature of the obligation requires solidarity. Okay, so solidarity, it may be on the part of the debtors, it may also be on the part of the creditors, or both. Okay? And solidarity may also exist even though unequal yung kanilang sharing. Okay, hindi naman porke solidary, dapat equal na yung sharing ng credit or ng debt. Okay, so it may still exist even though they are not bound in the same manner and by the same periods and conditions. Okay, so now let's go to the rules in solidarity. Okay, so let's start with solidarity as to debtors. Okay, so kapag solidary, ang mga debtors, kahit sino sa kanila, pwedeng singilin. Sino ang babayaran ng mga solidary debtors? Okay. Kapag solidary rin yung creditors, dapat magbayad yung debtors dun sa nag-demand. Okay? Nagbigay ng demand. Okay? So yun yung dapat bayaran nila. Okay? So since there is mutual guarantee among them, kapag may nagbayad ng buong obligation, yung isa sa kanila, then the obligation is extinguished. Okay? So kapag may isang solidary debtor na nagbayad, pwede siyang mag-claim ng reimbursement from his other co-debtors for their share. Okay? Pwede ring maningil ng interest. Except if the payment was before the due date. Okay, so kung before the maturity date of the obligation, nagbayad ka na, hindi ka pwedeng mag-claim ng interest. Okay, ito, important concept. If one of the solidary debtors cannot, because of his insolvency, okay, baka naging insolvent yung isang debtors, anong obligation ng other co-debtors? The other debtor shall borne the share of the insolvent debtor. Okay, so patak-patak sila, di ba? So they will borne the share of the insolvent debtor. Okay, kahit may insolvent na debtor, hindi ibig sabihin na may extinguish na yung part niya or yung share niya. Ang mangyayari, yung other debtors that are not insolvent, they will shoulder the obligation pertaining to the insolvent debtor. Okay, so proportionate. Okay. Number 4, in case the solidary debtors pays the obligation after the obligation has prescribed or become illegal, walang reimbursement. Okay? Paano kapag nagkaroon ng remission or condonation, for example? Okay. So for example, yung isang debtor pinatawad ni creditor, ibig sabihin ba niyan wala na siyang liability at all? Okay, so the answer is no. He is only released from his share but still has the responsibility toward the other co-debtors. Okay, kasi solidary. Okay, so yung hindi pa nababayaran, pwede pa rin siyang singilin. Okay, ang effect lang, yung share niya, ibabawas dun sa total loan. Okay, so kung may nagbayad na before the remission, then liable pa rin siya to reimburse. Okay, so what if, for example, solidary debtors, bawa si A and B. Okay. Tapos, isa lang na creditor. So, yung creditor lumapit kay A, sabi niya, okay, pinapatawad ko na yung buong loan nyo. Okay. So, the loan is for 100,000. Yung buong loan, ha? Okay. So, si A ba, pwede siyang mag-claim ng reimbursement, sabi niya kay B, oh, pinatawad yung utang natin kasi sa akin, dahil daw sa akin eh. And sa akin kinommunicate. So, bayaran mo ako ngayon ng 50,000. Okay. Sabi ng batas, you cannot claim from the other co-debtors for reimbursement. Okay, wala kang karapatan to claim for reimbursement even though the whole obligation was remitted because of you. Okay, you cannot be unjustly enriched at the expense of your co-debtors. Okay, as a solidary debtor, you can avail of the defenses that are derived from the nature of the obligation. So, for example, prescribed na yung obligation or illegal yung prestation. You can also raise the defense that are personal to you. Like, for example, your incapacity, for example, minor ka, or there was non-fulfillment of a suspensive condition. You can also claim the defenses that are personal to the other debtors. So, for example, yung isa mong debtors is minor, so pwede mo yun erase as a defense. So, pwedeng mabawasan yung obligation that is that you are obliged to pay. Okay, kasi you can claim it as a defense. Okay, so that are the rules in case of solidarity as to debtors. Now, how about solidarity as to creditors? Okay. In case of solidarity as to creditors, they may collect or demand the payment of the whole obligation. So, kahit sino sa kanila pwedeng mag-claim ng payment. Okay. So, pwedeng sabay, pwedeng samlang sa kanila, yung mag-demand. Okay. Each of the solidary creditors, they may do whatever that is useful to the others, but they may not do that is prejudicial. Okay. However, any novation, compensation, confusion, or remission of debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to his liability for the share of the solidary creditors. Okay? So for example, isa sa mga debtors without the consent of the other solidary debtors, pinatawad niya, for example, yung share ng isang debtor, then he is liable for the shares of the other solidary creditors. Okay? But that is valid. Okay? Kahit walang consent ng iba, for example, ni kinondone yung buong loan, walang consent ng other solidary debtors, it doesn't mean that the condonation is invalid or void. Okay, that is still valid. The only consequence is that the solidary creditor will be liable to his other co-creditors kasi walang consent yung condoned ng loan. Okay, so liable siya for the shares of the other solidary creditors. Okay. The solidary creditor cannot also assign his rights without the consent of the others. Okay, so those are the rules as to creditors in case there is solidarity among them. Now, what will happen in case the thing was lost or the prestation becomes impossible? So what will happen? Let us ask the question, is it with the fault of the debtor or without the fault of the debtor? Okay. Like for example, A, B, and C obliged themselves to give a car, for example. Tapos nawala yung car. Okay. If it's without their fault, then obligation is extinguished. If there was fault on the part of any one of them, for example, because of negligent driving, nasira yung sasakyan, then all of them shall be responsible to the creditor. For what? For the price and payment of damages and interest. Okay, without prejudice, of course, to their action against the guilty or negligent debtor. Okay, what if true fortuitous event, general rule, di ba, not liable, extinguish ang liability, except if any or all of the solidary debtors are in delay. Okay, so kapag may delay, lahat sila responsible pa rin kahit nawala yung thing because of fortuitous event. Okay, liable sila for the price, for damages, and for interest. So yung mga nagbayad na solidary debtors, di ba, wala naman silang kasalanan, pwede nilang habulin yung negligent debtor for reimbursement. Okay, so that are the rules in case the thing is lost or the prestation becomes impossible. Okay. The indivisibility of an obligation, like in our example, diba, A, B, and C oblige themselves to give a car. Diba? That is an indivisible obligation. Di mo naman pwedeng hatiin sa tatlo para yun yung share nila. Okay? So even though the obligation is indivisible, it does not necessarily mean na solidary na rin yung obligation. Okay? Kasi sabi natin, di ba, solidarity is not implied, it's not presumed, dapat expressly stated. Okay? And vice versa. Hindi ibig sabihin na solidary yung obligation, indivisible na rin. Okay? So they do not come together. They do not go hand in hand. Okay? So indivisibility refers to the object itself, while solidarity refers to the tie between the parties. Okay? So these are two different concepts. Okay, now let's give an example or a problem. Okay, so ginamit natin ang ating mga Olympic medalists. Ayan, congratulations, of course, to Heidelin, to Nesty, to Humor, and to Carlo. Ayan. Okay, so ito ang ating problem. Okay, so Heidelin, Nesty, Humor, and Carlo, our Olympic medalists, are solidary debtors of Nas, yan, and Luis. Okay, they are joint creditors for the loan of 200,000. Okay, all of the debtors are of legal age except Carlo, which is only 16 years old. Okay, our question, first question, how much can Luis collect from Nesty? Ayan, tingnan ulit natin sa Facebook kung may sasagot. Okay, so ang mga kasagot nito, bukod sa jowa, makakapasa sa CPA board, di ba? Lisensya bago jowa. Okay. Pwede na lang sabay, di ba? Kung bukod kang pinagpala. May sumagot na si Adele Rose. 200K daw. 200K. Si Maria Cristel naman, 75,000. Si John Lawrence Rosales, 200,000. Okay, more 200,000 coming in. Sabi ni Nasser Suleiman, 200K ata. Okay, hindi certain. Si Mariela naman, 100K. Okay, may 200K pa rin. Okay, sige. So, anong sagot? Okay. So, congratulations kay Maria Cristel Manalang Patulot. Okay. So, more chances of passing the board exams and having a jowa. 75K. So, paano yan na-compute? Okay. So, bibigyan ko kayo ng shortcut para hindi kayo malito sa mga ganitong mixed na solidarity or kung joint man or whatever. Okay. So kapag sa problem, kahit ilan pa yung ibigay dyan sa inyo na creditors or debtors, kapag solidary, you always consider it as one. Di ba? Kasi sabi natin one for all for one. Okay. So in determining kung ilan yung i-collect, ilan yung liability ng each party, okay. Kapag solidary, yung debtors or creditors, you always assign the value of one. Okay. Kapag joint naman, then bilangin mo ilan ba yung debtors, ilan yung creditors. So dito creditors, di ba? So merong dalawa. Okay, dalawa. Okay. So i-multiply mo yan, 1 times 2 equals 2. Okay. So kahit sino pa sa parties ang paikot-ikutin ka, like ilan yung pwedeng i-collect ni Nas kay Heidelin, ilan yung liability ni Heidelin kay Luis, ganyan. Ang formula pa rin natin ganyan. Okay, so i-multiply mo. So answer 2. Okay. The answer would easily be 100,000. Kaya nga lang, for those of you who are so excited, you failed to take note na si Carlo ay 16 years old. So sabi natin, kung ikaw ay kiniklaim or ikaw ay sinisingil ng isang creditor, you as a solidary debtor, you can claim the defenses that are personal to the other debtors. Okay, so dito pwede mong erase as a defense, huy, 16 years old yung isang debtor. Okay, so bawasan mo ng share niya. Okay. So, mangyayari dyan, yung share ni Carlo, di ba, na 50K, tatanggalin natin, 150K. So, since joint lang na creditor si Luis, i-divide natin dito sa nakuha nating product. 150K divided by 2, so 75. Di ba? Hindi ko na nasulat. 75K. Okay. Okay, mali na? Okay. Second question. Supposing Nas remitted the share of Heidelin in the debt. Sabi niya, for being the first gold medalist of the Philippines, I am remitting to you your share in the debt. So, our question, how much can Luis collect from Carlo? Sorry. Wait. Ano nangyari doon? Wait lang ha, sorry. Ano nangyari? Wait. Ayan, sorry. Okay? Okay, the answer is 0. Again, kasi minor siya. Yan. So, yan makikita kung sino ang may attention to detail. Okay. Now, what if ang imbis na si Carlo ang kinolektahan niya, si Luis pumunta kay Nesty, for example. So, what will be the liability of Nesty? So, magkano ibibigay niya kay Luis, for example? Palitan natin, hindi si Carlo. Paano kung si Nesty yung pinuntahan ni Luis, for example? So, remitted yung share ni Heidelin, tapos si Carlo, for example, like in our example, he's a minor, so ang pinuntahan niya si Nesty. So, magkano ngayon ang pwedeng i-collect kay Nesty, for example? So, palitan natin, hindi na si Carlo. Okay. So, in case that Luis proceeds to Nesty for the collection of the debt, he will only be able to collect the amount of 50,000. Okay. So, paano ulit yan na-collect? Ay, na-compute, I mean. Okay. Kanina, di ba sabi natin, yung share ni Carlo, parang ano siya it's effectively deducted from the total amount of loan. So 150K na lang yung balance, tapos ni-remit pa yung share ni Heidelin. So mababawasan ng another 50K. So magiging 100K na lang yung liability of the solidary debtors, kaya lang the creditor is joint. So, i-divide natin by 2, so 50K ang liability. Okay? Third question. 2 days after the remission of Heidelin's share in the debt, okay, Nesty became insolvent. How much can Luis collect from Heidelin, if any? Okay. Okay, so the answer to that, 50K. Okay. The fact of insolvency of Nesty does not reduce the amount of debt, di ba? Sabi natin, the only consequence, i-bear ng remaining debtors yung share ng insolvent debtor. Okay, so liable pa rin si Heidelin kahit ni-remit yung debt niya, yung share niya sa debt, kasi solidary eh. So liable pa rin siya sa share. Okay? All right, now let's go to divisible and indivisible obligation. Okay, so when you say divisible, it's capable of partial performance. When you say indivisible, not capable of partial performance. Okay, so take note that even though the object or service may be physically divisible, the parties can agree na indivisible siya. Okay, so kapag joint indivisible, it will give rise to indemnity for damages if in case any one of the debtors does not comply with his undertaking. Okay, indivisible eh. So hindi pwedeng hiwa-hiwala yung performance. So kung may isang debtors na hindi ready to fulfill with his obligation, he will be liable for damages. Okay, obligations with penal clause. So ito yung obligation na may penalty. Okay? So it will substitute the indemnity for damages and payment of interest in the absence of stipulation to the contrary. So pwede pa rin namang mag-agree yung parties na in addition sa liability mo for damages and payment of interest, meron kang liability. Okay? So this is obligations with penal clause. So the debtor cannot exempt himself na sabihin niya, bayaran ko na lang yung penal clause, hindi ko na i-fulfill yung obligation. Okay? So the penalty, yan yung compensation for non-compliance. Hindi siya substitute for the compliance or the performance of the obligation. Okay? So the nullity of the penal clause does not carry with it that of principal obligation. Okay? So kung void yung penal clause, valid pa rin yung principal obligation. However, if it's in the reverse, kung yung principal obligation yung void, yung penal clause void na rin. Kasi the accessory follows the principal. Okay? Now let's go to extinguishment of obligation. Okay, so ang mnemonics mo dyan, you can see this under Article 1231 of your Civil Code. So, palo, reme, kono, pare, fu. Okay. So, madali yan ma-memorize kasi parang parang do, re, mi, fa, sol, la, ti, do. Okay, so palo, reme, kono, pare, fu. Okay, so payment, loss, remission, merger, condonation, compensation, novation, prescription, annulment, rescission, and fulfillment of resolutory condition. Okay, but take note, this enumeration is not exclusive. Okay, meron pa rin other causes for extinguishment of obligations, like yung fortuitous event, diba? You cannot find it there. Okay, prescription. Okay, so hindi siya, dyan pala, prescription. So hindi siya exclusive. Okay, so you memorize this. Madali lang naman yan ma-memorize. Okay. Let's discuss one by one. So payment or performance. So when you say payment, it's the fulfillment of the obligation, di ba? Whatever has been contemplated by the parties. Some rules on payment. So dapat yung payment mo, it must be complete. Okay, hindi pwedeng partial. Okay, so no creditor cannot be obliged to accept partial performance. Okay, so dapat complete or full yung payment. Okay, exception if there was already a substantial performance in good faith, then the obligor may recover as though there had been a strict and complete fulfillment less the damages. Okay, or if despite the incompleteness or irregularity, the obligee accepts the performance, okay, without objection. So in that case, the payment is considered as if it's complete. Okay, another rule for payment, it must be indivisible. Okay? So, aside from dapat kompleto yung bayad mo, hindi mo pwedeng i-compel si creditor na part or by installment yung pag-receive niya ng obligation. Okay? So, dapat kompleto rin. Okay? You perform it in one circumstance or in one instance. Hindi pwedeng hiwa-hiwalay. Exceptions, if there is an agreement na pwedeng partial performance or unliquidated pa yung ibang part, or if it's already impractical na ipa-perform kay debtor in full yung obligation. More rules on payment kapag monetary yung obligation, dapat in legal tender. Okay? So when you say legal tender, this is the legal currency that is accepted in the Philippines. Okay? So negotiable instruments such as checks, bill of exchange, promissory notes, they are not considered as legal tender. Okay? So if the payment is by check, it will not produce the effect of payment until it is encashed. Okay? In case of extraordinary inflation or deflation, the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement to the contrary. Okay? As to place of payment, kung saan nila dinesignate, kung walang stipulation, kung naasaan yung determinate thing. Or kung wala pa rin in the domicile of the debtor. Okay. Ito, payment by third persons. Okay. When we say third persons, hindi siya party to the obligation. Hindi siya creditor, hindi siya debtor. Okay. General rule, the creditor is not bound to accept payment or performance by a third person. Okay. Exception, if the third person has an interest in the fulfillment of the obligation. So, sino-sino to? So, for example, a guarantor, a surety, a mortgagor, or a pledgor, for example. So, interested sila sa fulfillment of the obligation because they secure the fulfillment of the obligation. So, pwede silang magbayad. Okay? The creditor may be compelled or is bound to accept payment from these third persons who has interest in its fulfillment. And second exception, if there is a contrary stipulation. Okay. So what are the rights of a third person who made the payment? Okay. We distinguish whether it was made with knowledge and consent of the debtor or without. Kapag walang consent. Okay. Kapag walang consent or knowledge ni debtor, okay, pwede pa rin maka-recover si third person. However, it's only insofar as payment has been beneficial to the debtor. Okay? Up to the amount lang na na-benefit si debtor. And walang right of subrogation. Okay? Paano kung may consent and knowledge? Merong total reimbursement of what was paid and right of subrogation. Okay? Ito yung rights ng isang third person who pays the obligation with knowledge and consent of the debtor. Now we ask, paano kung ang nagbayad na third person is, for example, yung guarantor? Di ba? Siya yung guarantor, tapos binayaran niya ng buo yung obligation without the consent of the debtor. Okay. So ano ngayon ang mangyayari? Is he entitled to reimbursement plus subrogation or only reimbursement as payment has been beneficial pero no right of subrogation? Okay. So our rule to that, if the third person has interest in the fulfillment of the obligation, di ba? Sabi natin, the creditor is bound to accept payment. Okay. So even though without the knowledge of the debtor, he can still claim or he still has the right to be subrogated to all the rights of the creditor plus reimbursement of what he has paid. Okay? Who is entitled to receive payment? Of course, the creditor, his successors, and any person authorized to receive it. Okay? So, dapat magbayad ka lang sa authorized person. Kapag unauthorized yung person, invalid yung payment. Okay? Special forms of payment, you have the shonen payment, the application of payment, you have payment by session, tender of payment, and consignation. Okay, so isahin natin yan. When you say the shonen payment or what we commonly known as the shonen pago, so dito, there is a monetary obligation And in lieu of the monetary obligation, what was paid or what was given in exchange is a thing. Okay? So dito dapat may monetary obligation, tapos in exchange of the monetary obligation, ang binayad na lang is property. Okay? In order for there to have a valid dasyon and pago, the alienation of the property must fully extinguish the debt. Okay? Dapat may full extinguishment of the debt. Okay? So that's dasyon and pago. Ano naman yung application of payment? So application of payment applies when the following requisites concur. So first, there is only one debtor and creditor. Okay? Only one. Okay. So yung debtor, madaming utang kay creditor. Okay? And dapat yung mga utang parehong kind or identical. Okay? Like for example, parehong monetary obligation, although iba-iba yung due date. Okay? So all debts should be due and demandable. Okay? And the payment is not sufficient to cover all obligations. Okay? So for example, si A may utang kay B. Okay? So may 10K, may 20K, may 30K. Okay. Kaso ang pera lang ni A ay 10K. Okay. So kulang, di ba? Lahat ng to due and demandable na. Okay, lahat na sila nag-mature. So ano ngayon ang rule? Paano i-apply yung 10K na natitirang pera ni A? Okay, so these are our rules. Okay, paano ba nag-a-apply ng payment? Okay? So, first, the debtor is given the preferential right. Okay, siya ang pwedeng mamili. Saan ko ba i-apply yung 10K na pera ko? Sa 10K, sa 20K, or sa 30K? However, if the debtor does not make the designation, then the creditor will now apply the payment. Okay, so siya yung mag-a-apply. So, first priority, debtor's choice. Second priority, creditor's choice. Third priority, kapag hindi namili yung debtor or yung creditor, walang designation, then the following rules shall apply. Okay. First, the payment shall be applied to the most onerous debt. Okay. Like for example, dito, yung 20K may interest, yung 10K, 30K wala, then yung 20K siya yung most onerous, so dito i-apply. Okay? However, if they are of the same nature and burden, then proportionate. Okay, so i-divide. So 10K times 10K over 60K, for example. So proportionate. Okay? Ganon yung pag-apply ng payment. Okay. Payment by session, dito naman, madami ulit na utang, pero insolvent si debtor. Okay, dahil insolvent si debtor, ang gagawin niya, ibibigay niya lahat ng properties niya, except those that are exempt from execution, and then yung creditors tatanggapin yung properties. Okay, so dito pwede nilang ibenta, tapos yung proceeds paghahati-hatian nila. Okay, so necessary sa session na insolvent si debtor. Okay, that is why we distinguish sa dasyon and payment tsaka payment by session. Sa dasyon and payment, although property pa rin yung binibigay, di ba? Tapos yun na yung gagamitin na pambayad sa monetary obligation. Sa dasyon and payment, it's not necessary that there is a plurality of creditors. So pwedeng isa lang na creditor and hindi kailangan na may insolvency. Okay? And it is not necessary that it affects all the properties of the debtor. Okay? On the other hand, sa payment by session, dapat madaming creditors, insolvent si debtor, tapos it affects all of his properties. Okay? So that is the difference between dasyon and payment by session. Okay. How about tender of payment and consignation? When you say tender of payment, you offer. Okay? You present payment. Okay? Okay. Kailan ito ma-relate sa consignation? Okay. So first, you must tender your payment. You must offer payment as fulfillment or as the complete fulfillment of the obligation. Okay. If the creditor refuses, halimbawa nagbabayad ka na, kaya lang yung creditor ayaw niyang i-receive yung payment. Okay? Then that's the time that consignation will come in. Okay. So, ano ba yung consignation as a concept? So, consignation, may valid tender of payment, di ba? Nag-o-offer ka na ng bayad, kaya lang yung creditor ayaw niya tanggapin. Okay. So another remedy that is given to the debtor in order for him to extinguish his obligation is to consign the payment with the courts. Okay? So ibibigay niya, i-deposit niya sa judicial authority, sa korte, yung payment niya, and then the debtor may ask the judge to cancel his obligation. Okay? Kaya siya cause of extinguishing ng obligation. Okay? So may tender of payment, dineposit mo sa court, si judge mag-order na cancel na yung obligation. Okay? However, before that happens, kailangan i-inform mo si creditor. Okay? Na, ayaw mo tanggapin eh. Daling ko na lang sa korte, tapos dun mo na lang kunin. Okay? So, that's the time na pwede mag-order si judge. Okay, na-consign yung payment dito, extinguish na yung obligation. Okay ka na, debtor. Okay, bahala na si creditor kumuha ng bayad dito. Okay, so that's tender of payment and consignation. When will consignation produce extinguishment of an obligation even without a previous tender of payment? Okay? So, di ba sabi natin, wait lang, i-charge ko lang yung... Okay. Di ba sabi natin, dapat may valid tender of payment ka muna. Dapat nag-offer ka ng bayad bago ma-consign yung property sa courts. Okay. Kailan pwedeng i-consign mo na diretso sa korte even without valid tender of payment? So the following are the instances. First, if the creditor is absent or unknown, syempre hindi mo naman alam kung asan siya. So paano ka makaka-tender ng payment? Pangalawa, if he is incapacitated, okay, to receive the payment. Okay, so hindi na kailangan ng tender of payment. Or if he refuses to give receipt. Fourth, if two or more persons claim the same right to collect. And lastly, when the title of the obligation has been lost. Okay, so in the following cases, consignation suffices. Okay, so pwedeng diretso ka ng mag-consign sa court. Okay, so your mnemonics there are heir, TT. Okay, so absent, incapacitated, refuses to give receipts, two or more persons, title of the obligation is lost. Okay, so that's for payment. Now let's go to loss of the thing. Okay, so when is a thing considered lost? It's considered lost if it perishes, goes out of commerce, disappears, or its existence becomes unknown or cannot be recovered. Okay, so pwedeng mnemonics mo dyan ay dope. Okay, disappears, out of commerce, perishes, existence unknown. Okay, so going back to our previous discussion, kapag undeterminate thing na wala, extinguish ng obligation. Okay, exceptions, if it's due to the fault of the debtor, meron pa ring obligation, may delay, or the law itself provides, may express stipulation, the nature of the obligation requires the assumption of risk, or the debt proceeds from a criminal offense. Okay, and again, take note of this, if the thing that was lost is generic, then the obligation is not extinguished, because genus never perishes. Okay? In addition to the concept of loss, if the obligation to do, for example, becomes impossible. Okay. So, for example, may obligation ka to perform at an opera, tapos biglang nawala yung boses mo, for example. Wala ka namang kasalanan, nagkaroon ka lang ng sakit. So, hindi ka na makakanta. Okay. So, in that case, if it becomes impossible, physically impossible or legally impossible for you to perform an obligation to do, then you as the debtor is released from liability. Okay? And even though it's not impossible, but it has become so difficult as to be manifestly beyond the contemplation of the parties, then the obligation of the obliger may also be extinguished in whole or in part. Okay? If the loss was caused by a third person, for example, third person yung may kasalanan kung bakit nawala, then the creditor may avail of all the rights of action which the debtor may have against the third person. Okay? So those are the rules when it comes to loss of the thing. How about for condonation or remission? So when we say condonation or remission, pinapatawad yung utang. Okay? So it's a gratuitous mode of extinguishing an obligation. Okay? So dapat dito in-accept ni debtor. Okay? And dapat ma-observe yung formalities. Okay? Ano ba yung formalities for donations? So if a donation is movable property and it's more than 5,000, the donation and the acceptance must be in writing. Otherwise, the donation is void. Okay. If the property to be remitted or condoned is an immovable, then the remission and the acceptance must be in a public instrument. Otherwise, the donation or condonation is void. Okay, so yun ang required na formalities. Okay, in order for condonation or remission to take effect. Okay? Kapag may yung private document, for example, yung promissory note, napunta na kay debtor, there is a presumption that the creditor delivered it personally and meron ng condonation. But this is a rebuttable presumption. Okay, now let's go to merger or confusion. When we say merger or confusion, yung personality ng debtor tsaka creditor na merge sa isang tao. Okay, so since nabalik or na merge sa isang tao yung personality ng creditor tsaka debtor, di ba? May extinguish yung obligation. Hindi mo naman pwedeng bayaran yung sarili mo. Di ba? Like for example, si A nag-execute ng promissory note kay B, granting for example negotiable promissory note, tapos si B in-endorse niya kay C, tapos si C in-endorse niya ulit kay A. Okay. So, since nagkaroon ng merger ng qualities or personalities ng debtor tsaka creditor, extinguish na yung obligation. Di ba? Hindi mo naman pwedeng bayaran yung sarili mo. Okay? So here, merger will extinguish the obligation. But take note that this should apply to the person that is principally liable. Okay? Kasi kung ang merger, it took place in the person subsidiarily liable, like for example, sa guarantors or sa surety, di ba? Sila yung naging creditor bigla. Then there can be no extinguishment of an obligation kasi dapat sa principal, debtor, or creditor. Okay? Kung sa guarantors or sa surety, yung merger confusion, it will not extinguish the obligation. Now, what if the merger took place in a joint obligation? So it will not extinguish a joint obligation except the share corresponding to the creditor or debtor kung saan nag-concur or nag-merge yung character as a creditor or debtor. In solidary obligation naman, it extinguishes the whole obligation. Kasi again, sa solidary obligation, one for all for one. Okay? Now, compensation. Okay, compensation naman, sa madaling sabi, di ba, in layman's terms, ito yung tinatawag na quits. Okay, quits na tayo. Okay, so here, the debtor and creditors are creditors and debtors of each other. So, I owe you, you owe me. Okay, so since meron kang utang sa akin, may utang rin ako sa'yo, i-offset na lang natin, di ba? I-offset na lang natin, tapos quits na, di ba? Wala nang singilan kasi wala na rin namang sense na magpalitan pa tayo ng pera kasi may utang naman tayo sa isa't isa. Okay, so that's the concept of compensation. Okay, so in addition to that, dapat principally liable sila dun sa utang na yon, and the debts must consist in sum of money. Okay, or if the things are consumable, dapat same kind and quality. Okay, dapat due na and demandable yung both na utang. Okay, dapat walang controversy surrounding the debts. Okay, walang maapektuhan na third persons. And it must not be prohibited by law. Okay. So, there are debts or obligations not subject to compensation. Meaning, kahit may utang ka sa akin, may utang ako sa'yo, hindi mo pwedeng i-compensate or i-offset. So, what are these? So, debts or obligations arising from contracts of deposit. Okay? Debts arising from obligations of a depositary. Hindi rin pwede. Okay? Debts arising from obligations of a bailey incommodatum. Yan, hindi pwede. Claims for support due by gratuitous title, hindi pwede. Okay, like for example, ikaw may obligation ka to support me and then may utang ako sa'yo, hindi pwedeng i-offset natin. Okay, hindi siya allowed by law. Okay, obligations arising from criminal offense and certain obligations in favor of government. Okay, so for example, may utang si government sa'yo. For example, contractor ka. Kasi hindi ka pa nababayaran ng government agency. Hindi mo pwedeng sabihin na, ay may unpaid taxes ako, offset na lang natin na. Hindi pwede. Okay, so these are debts or obligations not subject to compensation. Okay, however, okay, so before we go to that, however, Let us first discuss the kinds of compensation. So, legal compensation by operation of law, meaning kahit walang agreement yung parties by operation of law, upon satisfaction of the requisites enumerated by the law itself, by operation of law, then offset na, compensated na yung debts. Conventional, this is by agreement of the parties. So, since by agreement, kahit wala yung iba sa mga requisites that we enumerated, like for example, hindi pa demandable yung utang ng isa. Kapag yung parties na yung nag-agree na, sige, i-offset na natin, okay na yan, quits na yan. Then, the obligation is already extinguished by compensation. Okay, judicial, ito naman by court judgment. Okay. Number 4, facultative. Okay, ito yung compensation which may be claimed or opposed by one of the parties. Okay. Di ba, in-enumerate natin to. Debts or obligations not subject to compensation. Okay. When we say facultative compensation, yung mga parties who can object na, hindi mo pwedeng compensate. Like for example, sa support, di ba? Ikaw, liable ka to support me. Hindi pwedeng sabihin mo na offset na lang yung sa utang mo sa akin. Okay. Yung party na may right to claim that or oppose that compensation, he may waive that. Sabihin niya, sige, may karapatan ka to support me, tapos may utang ako sa'yo. By facultative compensation, pwede na nating i-offset na lang. Okay. Kaya lang, ang dapat mag-raise nun or dapat magsabi na, sige, i-offset na natin, is the parties who has the right to oppose the compensation. Okay? So, in case of support, yung party who is supposed to be supported. Okay? However, hindi pwedeng i-offset yung future support. Dapat existing na siya. Okay? So, when one of the debts arises from the following, yung parties who can oppose to the compensation, they can waive that opposition and then claim for facultative compensation. Okay, so parang by agreement of the parties lang. Ang only difference is, merong express prohibition kasi by law, but they can still waive that, okay, by agreement. Okay? Lastly, novation. Okay, ano naman ang novation? Okay, so novation, this is the substitution or change of an obligation by another, resulting in extinguishment or modification. Okay, so ano ang mababago sa novation? Pwedeng condition, pwedeng yung personality ng parties, or pwedeng yung object. Okay, so sa novation, nagbago ng object, nagbago ng principal condition, or napalitan yung personality ng debtor, tsaka yung personality ng creditor. So, requisites of novation, dapat first may valid old obligation. If the old obligation is already void, okay, for example, the old obligation is already void, the illegality or the fact that the old obligation is void, it cannot be cured by novation. Okay, so the novation is void if the original obligation is also void. Okay. However, if it's just voidable, then the novation is valid. Okay, but there's still a right to annul the obligation if the defect still is present. Okay, so first requisite, dapat yung old obligation mismo valid. Okay, second, there must be an agreement between the parties to extinguish or modify the old obligation. Okay, so dapat sila mismo nag-agree. Okay, hindi pwedeng i-presume or implied na agreement. Dapat nag-agree sila. Exception, when the person of the debtor is changed, which can be made even if it's against the will of the debtor. Okay, pwedeng paritan yung person ng debtor kahit labag pa sa loob ng debtor. Okay, and the next exception is in case of subrogation. Di ba? If a third person pays in behalf of the debtor and merong knowledge or interested siya sa fulfillment ng obligation, meron siyang right to be subrogated. Okay? Number 3, dapat ma-extinguish yung old obligation. So, kapag may novation, ang na-extinguish yung old obligation pero merong bago, may valid new obligation. Okay? As to kinds, so we have real or objective. So, dito ang napapalitan ay object or principal condition. Example, A obliges himself to give a car to B, for example. So there is a real or an objective obligation if instead of giving a car, the object now becomes money. Example, so there is novation. Okay. Novation can also be personal or subjective. So here there is a change of parties. Okay, so it can either be the creditor or it can also be the creditor. If what is being substituted is the person of the debtor, it should always be with the creditor's consent. Okay, hindi pwedeng palitan yung personality of the debtor without the creditor's consent. Pwedeng palitan yung debtor even without the debtor's consent, pero dapat laging may consent ni creditor. Okay. Substitution in the person of the debtor can also be called as expromission or delegation. Ito naman, ang difference lang nito, sa expromission, ang nag-i-initiate ay third person. Sa delegation, ang nag-i-initiate ay debtor. Okay? Of course, we also have the concept of subrogation. So we have conventional, this is by agreement. Legal, this is by operation of law. Okay? So when is there a presumption of legal subrogation? If the creditor pays another creditor who is preferred, even without the debtor's knowledge, okay, then merong subrogation. When a person, third person not interested in the fulfillment of the obligation pays with the express or approval of the debtor, may subrogation. Di ba? Na-discuss natin under Article 1236 and 1237. Okay. Ito, yung sinabi ko kanina. Paano kung ang nagbayad na third person ay interested in the fulfillment of the obligation? So, meron siya right to be subrogated even without the knowledge of the debtor. Okay? As to form, pwedeng express, pwede ring implied. Okay? In order for there to be an implied novation, dapat incompatible on every point, yung old and new obligation. Okay, what is the effect of the novation on accessory obligations? Okay, so for example, A obliges himself to pay B 100,000 by agreement of the parties. Biglang ang gusto na lang nila is A will deliver a car, for example. However, the monetary obligation of A is secured by a guarantee executed by C. So ano magiging effect ng novation of the object between A and B? Okay? If the principal obligation is extinguished, okay, then the accessory obligation will also be extinguished. Okay. Except in the following cases. Okay. So dito, di ba, hindi naman na-extinguish, so pwede pa rin mag-exist yung guarantee. Okay. Except in the following cases. Okay. When the accessory obligation was established for the benefit of third persons who did not give their consent. Okay? Or may stipulation na kapag nag-novate, extinguish na rin yung accessory obligation. Or number 3, when the novation is one where a third person is subrogated in the rights of the creditor. Okay? So those are the effects on accessory obligation. Okay. So sabi natin kanina, kapag ang old obligation is void, ang novation, hindi niya makukure yung defect ng voidness ng old obligation. So the old obligation will remain to be void. Now what if yung old obligation valid, tapos yung new obligation by reason of novation void? Ano magiging effect? Okay? So under Article 1297, kapag void yung new obligation, ang effect niya, yung original one, siya yung magsasubsist. Okay? So as if walang novation. Okay? However, if the parties intended na talagang extinguish na yung old obligation, then wala na. Wala nang obligation, either old or new. Okay? Now, what if there is a condition that was attached to the original obligation? It will be transferred or transmitted to the new obligation. Okay. All right. So, last example before we end. Okay. Nasagad ko pala yung 2 hours. Okay. So, what if si Rody, he obliged himself to deliver 50 grams of shabu to Peter in exchange for 100,000. Fearing for his life, Rody asked Peter if he could just deliver 100 sacks of rice, to which Peter agreed. Our question, is there a valid novation? Ayan. So, last question na yan. Ano ba ang pwedeng ano? Ang makakasagot nito, Congrats. So sabi ni Laika Ocampo, yes. Sabi ni Hanadi Taha, no, it is void. Okay. Si Donna Pearl Mansurado, yes. Si Vin, yes. Okay. Bakit may sumasagot na na? Ah, okay. Is there valid innovation? None. Okay. Sabi ulit ni Maria Cristal Manalang Patulot, no. Sabi ni Butch, no. Okay, no. Okay. So let's reveal the answer. The answer is no. Okay, very good. Why? Because like what we said earlier, one of the requisites in order for there to be a valid novation is a valid old obligation. So, di ba? Yung old obligation dito, void pa lang eh. Kasi illegal yung object, di ba? 50 grams of shabu. So the defect in the old obligation cannot be cured by subsequent novation. Okay? So therefore, there is no valid novation. Okay? All right, so that ends my discussion for your law on obligations. Sorry for dragging it too long, but you know, law on obligations is really long. But hopefully, I was able to discuss it comprehensively so you can understand. Okay, so if there are any questions, again, I will allot siguro 5 minutes kasi I'm already beyond my allotted time. Gusto may magpabate? Charot. Okay, may mga sumasagot pa. Mukhang delayed ang kanilang telecast. Sabi ni Vinvin, shabu pala. Okay, shabu pala. So hindi na So when you are answering questions, law questions, madami dyan most of the time ng mga tricky, di ba? So basahin niyo ng mabuti. Okay, the one trick or one tip I can give you in answering case type questions, like for example, you are given case type questions that are multiple choice. You read first the question, okay? And if it's too long, you can read the last 2 sentences. Because when you read the question first, then you already have a guide or an idea what to look out for. Unlike if you read from the very start, so it's possible that you will be tricked or you will your attention will be caught by some unimportant detail and then you focused on it, you dwelled on it, tapos yun na yung naisip mo na sagutan, di ba? Unlike if you read the questions first, and then you will have a guide, di ba? Magigets nyo na, ano ba yung kailangan kong hanapin, di ba? So, ayun. Okay? Sige. Thank you so much. Wala kayong questions? Kung meron man, tag niyo ako sa Twitter. Joke lang. Sige. Thank you so much for bearing with me tonight. And enjoy the rest of your Saturday. Diba? Take a rest. You deserve it. But wag naman yung rest lagi. Okay? So, give yourself a break. Eat well. Diba? Sa mga hindi pa nagdi-dinner like me. So, eat well. And then, siguro watch a movie or a series. It's Saturday night, so give yourself a break. And then, after that, continue ulit, di ba? Grind ulit. Okay? Sige. Maraming salamat ulit. Thank you so much to everyone and I'll see you again next time. Thank you.
Thank you, Attorney.
Thank you. Pwede na mag-leave?
Opo. Salamat.
Thank you.